Live from Seattle with Michelle Mendoza resumes.
Today we are taking on the issues of the day, News and Views Thursday.
News and Views Thursday.
And plenty has been coming out of the Supreme Court and our legal system. And so, of course, we go to solidcounsel.com and dig up live from Seattle's absolute favorite attorney, Byron Henry. Thank you for staying with us, delving through some of the rulings from the Supreme Court. And we can just start with the big one. It was shocking to him. Well, there's a few big ones. Let's start with the abortion issue. Very shocking to the pro-life movement and hailed as a great victory to the pro-choice movement. What is the outlook going down the road from this?
Well, I think initially it was a surprise to the pro-life movement that Justice Kennedy not only didn't write the opinion, but that he joined Justice Breyer's opinion in full without any type of comment of his own discussing the regulations in question. He basically bought the abortion advocates' argument that these requirements, that doctors meet certain requirements by having admitting privileges, and that abortion clinics be certified or meet the standards as ambulatory surgical centers, were basically a ruse or a sham to somehow create an obstacle or restrict a woman's right to obtain an abortion.
Just confuses me, though, Byron, because whether their intent shouldn't really matter. Is it a ruse? Was it just a way to limit them? I don't know, but it just sounded like a good idea. To me, it's the same as saying, well, you know, if someone's going to get an abortion, there should be a doctor. They should be a doctor there, someone with medical training, rather than just having it done like when you can go get your nails done and then sit in the next chair and get an abortion. No, it should be done by a doctor. You know, that's the same kind of logic that was behind this Texas law, in my opinion.
Certainly, and some of the laws or things, some of the provisions in the law that were pointed out by Justice Alito in its dissent were simply that the abortion clinics meet certain fire codes, other safety requirements that other buildings, in fact, have to meet.
Other businesses have to. I mean, I owned a dance studio here in Washington State. I had to be subject to certain codes and regulations, even some that seemed a little bit outlandish for what I did, but it's just the law.
That's correct, and certainly the court, you know, basically is not taking the word of the state and its legislatures when they pass a law which doesn't even deal with a woman's right to an abortion. It deals with the purveyors of abortion, the actual clinics and the doctors that do the abortion. So what it does is basically serve notice that if you're going to pass a law which supposedly is designed to enhance women's health, these laws, because they affect abortion, have a much higher burden, or a much more difficult burden to overcome, because it's abortion. In fact, abortion is now basically climbed to the top of the rights in the pantheon of constitutional rights, despite the fact that it's not in the Constitution.
Okay.
And so it's really hands off that right, which is kind of odd, because the left is always saying that although the right to bear arms is in the Constitution.
Thank you. That's where I was going to go. I
I
was just going to go right down that route and say, wait. I need some clarification here. Treat this poor, simple girl, you know, gently, because I'm not getting it. Because in the media, I've heard a lot of statements about your constitutional right to an abortion. You have a constitutional right to abortion, and those rights should not be abridged. But why is your Second Amendment right? You know, and again, you may be tuning in for the first time. I'm not here to just champion everybody having a gun or stand on one side or the other. I'm just simply stating, hello, this is a constitutional right, and everyone is okay with abridging that right. Everyone seems to be okay with taking it away, and you have to apply for a license in order to have this constitutional right. And it's becoming a very convoluted issue.
Certainly, and the problem is that with almost all constitutional rights, the left is exactly correct. They're not absolute. They are subject to regulations, both that were in effect at the time of the ratification of the Constitution and the Bill of Rights, and that includes some restrictions on free speech, such as defamation and other things. It includes certain things like owning certain type of weapons under the Second Amendment and people that are felons or unfit mentally to have firearms. Those aren't in question, but the issue when it comes to abortion, it seems to have its own special whole lexicon of tests and standards that it's basically becoming virtually impossible for legislatures and others to meet pre-viability.
We are out of balance in America. Take the affirmative action ruling that happened, Fisher versus the University of Texas. This is one that many people hadn't heard of. It was basically a young student, Abigail Fisher, a white student, was rejected by the University of Texas. She said she was denied the equal protection of the law because race was a factor in who was admitted. She's white, and so she's not worthy, basically.
Well, and one surprising thing about this case, or one thing your listeners should note, is that this is a very narrow program. In order for this to pass muster with Justice Kennedy, who is very skeptical of race being considered in any government decisions, he's been pretty consistent in that respect. In fact, this may be the first opinion he's ever joined that approves of race as a factor in public government decision-making. Texas had to basically say that this race was such a minor factor. It was a factor of a factor, and it was very narrow, and the court referred to the University of Texas's program as basically unique and very limited. And so basically what Justice Kennedy said was he blessed this use of race in very narrow circumstances when race is a minor factor. And he, served notice that while race is not 100% off limits, that universities are not allowed to simply throw race in there as one of the factors to consider, but they need to have a program that basically proves to the courts that race was the only way you could get to where you were going, which is basically the test he laid down.
That is what we need to hear. However, what's being touted is something entirely different. When you hear this ruling, the folks are saying, and they're talking about, look, affirmative action needs to be upheld. This is quite important. We do want to have diversity. So this is what I'm talking about with some of the issues coming out of the Supreme Court. The issues coming out versus how do people accept them? What do we see them as? One issue that they did not hear was birthed in Washington State, and that was dealing with the pharmacists who had a religious objection to giving things like the morning after pill. Them not hearing it, and according to lower courts saying, look, no, you do have to give it, but you can't have an undue burden because of your religious conviction. That's the reality, and yet what people are touting is something different. And that's why I'm really interested in what you think is going to be happening moving forward and how these issues are going to be used as political ping pong balls.
Well, I certainly think that if the trend continues, what you're going to see is, especially if we have a president, whether it's President Trump or President Clinton, that appoints justices that are more left of center or liberal in their constitutional thinking, what you're going to end up with is a country that prizes abortion rights, is less protective of First Amendment rights, including participation in elections and electioneering and giving money in support of your candidates. And certainly that is important. But the religious freedom issue is huge because Justice Alito mentioned in his denial dissent in that case that this is a very bad omen for religious freedom if you can basically force people to violate their consciences or move professions or leave their job, which is basically the way this works. And it's actually the other way, is the way the Constitution and case law from the past has been going, is that people have a right to their job and to their religious conscience unless you show that there's no way they can do their job and have their religious beliefs accommodated. And so it's almost like it's flipped the burden from someone proving that this doesn't infringe on their religious belief, the proving that it does infringe on their religious
How
belief.
interesting. At the same time, we're seeing in other courts the switch from having to prove guilt to having to prove your innocence. So there's some disturbing things, but talking about it and making America aware, that's part of the solution, because we can be people who vote. We can be people who are part of the change, because this is still, even though it doesn't always seem like it, a country of, by, and for we the people, and we the people like Byron Henry. He's our favorite attorney. Thank you so much for joining us. It is always a pleasure. We learn a lot from you.
Anytime, Michelle.
God bless. You can find Byron at solidcounsel.com. I'm sure that's what he provides. I mean, he's a solid guest after all. As we continue live from Seattle,